So we can start.
Very good afternoon, dear students. Today we have the third part of this lecture course on research methodology, research and publication ethics, and innovation and IPR. To deliver these last 5 lectures, we have with us Professor Prabuddha Ganguli, who is presently the honorary professor at HBNI. Professor Ganguli is a renowned IPR expert and an author of several books on IPR. He is a PhD from TIFR and briefly worked in BARC before moving to Hindustan Unilever Corporate R&D and IP Management. He is one of the founding members of Rajiv Gandhi School of Intellectual. Sorry, there is a phone call. He is one of the founding members of Rajiv Gandhi School of Intellectual Property Law, IIT Kharagpur, where he contributed immensely to the development of curriculum of several courses on IPR. He continues to be a visiting professor in IIT Kharagpur. As an honorary professor in IIT Jodhpur, he helped draft the IPR policy. He was also the honorary scientific consultant for innovation and IPR matters to the Office of Principal Scientific Advisor, Government of India, from 2005 to 2018. He was the chairman of the Jury Cum Selection Committee in 2019 to identify and shortlist the entries received in the Grand Challenges project of the Atal Innovation Mission by Niti Aayog. He held the Ministry of Human Resource Development IPR chair professorship at Tezpur University, Assam during 2012 to 2017. He will be delivering 5 lectures on integrating IPR in the innovation value chain, basic understanding of tools of IPR such as patents, copyright, designs, registrations, etc. Role of IPR in collaborative work, technology acquisition, transfer, commercialization, and trade. So I request Professor Ganguli to deliver the lecture, please.
Well, thank you very much, Brother Tomar. Of course, it's a great honor to conduct some of these sessions with you. What I'm going to do is, as a part of this course, try and show you how this whole area of intellectual property rights becomes an integral part of the innovation value chain, of which you are already a part. Because you're doing research for your PhD, therefore you're a part of the innovation value chain. And we want to look at how intellectual property rights forms an integral part, and the important word is integral part of the IPR value chain. So the question is that as we do our research, how do we integrate IPR into our work processes? And how do we work out that if we, or more important will be that if we do not do it, what do we lose? And the important part is that if we do it, what do we gain? So we will look at all these aspects. And what I plan to do today is to give you an overview of intellectual property rights to start with. And then from tomorrow, I will go into the area of patents in fair detail. So having given you these introductory remarks, just before I start, in case you want to ask me any question at any stage, please go and raise your hand and you will be unmuted so that you can ask the question at that point in time. So I would not like you to ask questions at the end. Please stop me whenever and wherever you would like to ask a question. So please use the raise hand symbol and somebody will, immediately sort of unmute you so that you can ask your question. Well, with these few introductory remarks, let us start. So start with, as we go along, that when you look at the entire societal framework, when you look at the societal framework, society has to grow. And if society has to grow, in a sustained way, then we all understand today that innovation and research is an integral part of societal growth. And how does societal growth take place? It takes place through continual, mind you, it is not continuous, but continual research and innovations. And mind you, I've made a differentiation between the words research and innovation. I'll come to that later. And when we do that, whatever we do must be decisive, it should be definitive, it must, sustain excellence, it must be inclusive, that it must try and cover, almost everyone, as many people or as many sectors as possible. And it's got to be fair. And all these have to be in dynamic synergy. When we do this, society, that if the societal growth has to take place, there are different operators in society who have to interact dynamically with each other. So who are they? One is what I call as well springs of knowledge. For example, HBNI and all the associated institutions in HBNI are well springs of knowledge. Why? Because they're crucibles of learning. And in these crucibles of learning, we develop knowledge, we enrich the knowledge domain. So all the institutions who are involved in education and R&D are constantly, populating the energy domain. That's one part of the operating stakeholders. Then, of course, we need funding agencies. For example, DAE is a funding agency, so it's a nourishing source. So they fund all the research that we do. Government of India does that as well. Then, not only that as we do our research and get our results, one, of course, it enriches the knowledge domain. The other part is that we would like to convert this knowledge into usable knowledge. We would like to convert them into products, into processes, into services. And to do that, you need a separate channel, what I call as knowledge converting channels. And these knowledge converting channels are entrepreneurs, industry, NGOs, government agencies, so on and so forth. So those are the places which convert this knowledge and takes it to society so that society can use it effectively. And then to do all this, we have facilitators, like, for example, the governments. Government of India has a whole range of policies to govern all these things. So therefore, we have that. And all these things, all these activities operate within what I call as ethical and legal pathways. So these are governance frameworks. These are laws on one side, regulations on the other side. So, for example, if you take the Atomic Energy, Commission, and if you take all the work that goes on in atomic energy out there, we already have a regulatory agency that looks after all these particular aspects out there. Similarly, there are different laws for different aspects of these activities. So this is the broad framework in which society operates. This is a broad framework in which we all operate. You are operating, I am operating, so is everyone operating out there. Now, we go further into this. So this is the first part. And this is how society, goes forward and gets into this. Let's come to the word innovation. See, when we do research work, we enrich the knowledge domain, we find new things, we work those things out. Now what happens is that we take some of these results, and when we take these results and actually transform them into tangible gains, into tangible products, tangible services, tangible processes, we take it to the society and society uses it. It is at that stage that the research results get converted to innovations. So innovation is the one which is the ultimate. Research results are sort of, you may say, a prelude to the innovations. But all this leads to innovation depending on how we do it. So when we come to innovations, where do you start? You start with ideas. Ideation is the starting point of innovations. Then what happens? From ideation, you go to the proof of concept. You develop a proof of concept. So from ideation, you go to proof of concept. Then what happens? When you're at the proof of concept stage, that you've established, well, I have an idea, I think it works. So when you think it works, you try and establish that particular proof of concept. And as you establish the proof of concept, the next stage of that is where you go into the developmental phase, where you develop this particular proof of concept into certain areas. Well, either it's a product or it's a process or service or a combination of these. It can be product and processes, product and services, services alone, product alone, whatever they may be. So very important that when we do all these things, the developmental work is the one where we take the research results, we scale them up to see whether they are reproducible, whether they can be scaled up, and not only scaled up, at that stage, we try and explore, how we can make them tangible, and not only make them tangible, but then we start exploring options to look at how we will take them to the marketplace, what will be the sort of costing, what will be the price, the commercial aspects, etc., etc., etc. So the technology transfer and all those things happen at that stage. That's a very important stage in the life cycle of innovations. And then when we go to the market, we come to the commercialization of the tangibles in the marketplace. And a very important part in the marketplace, that when we take these products, processes, or services to the marketplace, the societal acceptance is a very important part. Because if society does not accept, it does not sustain in the market, and in which case it just falls off. And therefore, this societal acceptance is a very important aspect of whatever we do. So we cannot keep that. Our consumers are very important from our point of view. And the consumers change with the context of innovations that we are there. Now, interestingly, what has happened over time? And today the reality is that innovation life cycles, the innovation cycle times have crushed. Earlier, if you went back by 50 years or 40 years, you had an innovation, it would stay at least in the market for a certain length of time. Today, by the time innovation A comes in, the innovation B is practically, just about following it, and innovation C is just about to follow it, which means that innovation cycle times are reducing drastically. Number one. Number two, we are very clear products and services are getting into a process of quick obsolescence. So we need to innovate fast. We need to come very quickly. Therefore, we have to beat the obsolescence area. Third, very important part is that knowledge. We need to access this. The dynamic knowledge access is number one. You access the knowledge. Then you use the knowledge. Then you reuse the knowledge. You create knowledge and you market the knowledge. Even marketing a product is like marketing a knowledge. Marketing a process is marketing knowledge. Because that process, that product or service has so much of knowledge embedded in it. And all this is very dynamic today. So in this dynamic situation, when you're doing your research and everything, you're meeting these realities every single day. And of course, very important that we have realized collaboration is important, networking is important, sharing is important. Now, when you do all this, you need also to selectively, mind you my word, selectively protect the knowledge that you've created and developed. You share, but selectively some of the knowledge that you've developed, you may like to protect it. You may like to create that particular protection. And not only that, you want to continually benefit from that so that you can sustain your research, so that you get funding, etc., out there. So these are important aspects in research process, in the innovation process, where you collaborate, you network, you share, and then you selectively protect. You don't have to protect everything. So you selectively protect what you want to do. That's where intellectual property rights comes in. When you benefit from for sustenance, and also the concept of intellectual property right comes in. And therefore, the entire innovation process today becomes a very strongly intellectual property rights driven process. Therefore, you need to integrate IPR into the entire innovation. At this stage, are there does anybody want to ask me any question? At this stage, before I proceed any further, does anybody want to ask a question? Please raise your hand, in which case you will be unmuted. And if there are no questions, I will go further. So since I have not seen any raising of hands, I assume there are no questions. I will wait for a few seconds just to see if there are any raising of hands coming in. So I've not seen any raising of hands. Therefore, I'll proceed with the next part of my lecture. So this is very important, that in case of innovations, we need to look at it holistically out there. Let's go further. Let's go further. Now, so when we come to all these areas of innovations, what are we doing? We have we get an idea, we transform that idea. We make a change, we transform it. And then when we transform, we then translate that idea into products and other forms. And then if I am not going to take it to the society, I'm not going to commercialize it, what do? I transfer all this to an agency or some people or some organization who will then take these thoughts to what I call as make them into tangible assets. They're not just products. Please mark the word asset. When do you use the word asset? That when a product gets a certain value, it becomes an asset. And therefore, we want to convert the products of our research into tangible assets. Very important that we want to convert them into tangible assets. That is where thoughts to tangible assets is something that we would like to do. Now, this type of a thought process, when I was doing my PhD in TIFR, that is way back in 1971-72, we were never told that you will convert your thought processes into tangible assets. We always thought we were only enriching the knowledge domain. Today, it's become extremely important and significant that what knowledge we develop, whatever we create, at least some part of it, we should be able to convert that into a tangible asset. And if we want to convert that into a tangible asset, then IPR becomes a very important part of this particular process. So this is something that we need to recognize and appreciate. Now, how do we do that? So the first part, as all of you as research workers, what have you done? You have tried to identify some unmet needs of society. Something that you thought that you may like to address and take that unmet need and convert that and provide a solution to that particular problem. In which case, the question that comes that if you did that, for example, if you were doing some work in the field of mathematics and you came with a new formula, the question was that it not only would address some basic aspects in mathematics, but then you must also start thinking that with this formula, what can one do? Where can it be applied? And how it can be used, possibly for solving some problems, unmet problems, unmet needs, solve those unmet needs of the society. That would be taking it to the actual limit. Then envisioning beyond the horizon while creating innovation value chain to ensure. So you need to work this out in such a way that you not only are going to address your peer group, but you will go beyond peer group as well. And therefore, it's extremely significant for us today that certain parts of the knowledge that we create, can we identify that in this knowledge value chain or the innovation value chain, which part I am going to be involved, where I will pass it on to others who will do it. I don't have to do everything myself. I may develop it, but I may not be doing the commercialization. I may give it to somebody else to do the commercialization because I think I'm capable of doing this part and not that part. Fair enough. But I have to identify that part of that. So involvement of the delivery, I must. Very important, therefore, is these aspects of tactical partnerships, collaborations, and exploiting interdisciplinary experience and transacting intellectual property. And I will address all these issues as we go on. And in doing this, as we said very clearly, that the societal engagement is very important because why? If if I develop any product or process or services, the society wants to use it, society will have to accept it, and therefore cultural compatibility of certain things to ensure that the absorption, diffusion, acceptance of the end products actually goes into society. So these are the overall, aspects. So when we do research, we have to be holistic in our thinking. I may do a small part of it. That is fine. But my thinking has to be holistic. And mind you, you are, since you're involved with DAE, I would say that I'm a great beneficiary of the DAE in India, that having been in an organization like TIFR and for some time in BRC at some stage, one had the benefit of the great thinkers in this country who actually created these institutions with the purpose. And that is where you are involved, we are all involved, and we must know that particular part and the role that we are playing. So what happens? In our innovations, we do various types of innovations. One, very clear, where we use methods of science and technology. There we are developing products, we are developing devices, we are creating new plant varieties, we are creating new seeds, we are creating new microorganisms, we are developing new computer programs, and all those things. Why are we doing? Because we are trying to bring in technical improvements related to functionality in a contextual sense. That is one type of work we do, where we are addressing issues of functionality. I develop a better catalyst. I develop, a material which can cure cement very, very quickly. I do something in mechanical engineering so that I increase the strength of some materials so that they can go into bridges or whatever, and give the strength to those functionality. Very important. Or I do genetic engineering so that I come to a stage where I give a better functionality to those particular genes or whatever. So functionality and improvement of functionality is a very important aspect that we do research on. That's one part where we use a lot of aspects of science and technology to address those issues. Number one. Then there are other types of innovations we do. Do those where we address distinctive shapes and ornamentation. For example, if I take my specs, now these specs, you can see the shape of this lens and the frame. Now, this one could be round, could be, angular, could be anything. Now, if the power is the same, functionality is the same, shape, ornamentation becomes aesthetic features. But then consumers also require aesthetic parts. So people also innovate to develop new aesthetics on material, on different products. And that's where we are not looking at functionality, but we are only looking at aesthetics. That's another type of work, another type of innovation, where the function is being disregarded and looked at the aesthetic aspects. Even those are important because they find acceptance in the marketplace. And then, very important, we write, we draw, we paint, we sculpture, we take photographs, we do all those things. We write a poetry, we write prose, we write novels, we make films, whatever. And those are expressions of the human mind. So we do creative expressions. There are also different types of creative expressions. So innovations are not only on science and technology, it cuts across all disciplines. And if you take humanities, for example, then if I develop a model by which I'm able to teach better, I'm able to reach the public better, the absorption of this with the public is much better, then I'm also doing innovations in humanities out there as well. So innovations have different forms and the ways we do it. Because science technology is only one part. Everything else comes together with it. And that is all what constitutes innovations in general out there. Now, again, any questions at this stage? If there are any questions, please feel free to raise your hand. I've not seen any hands raised, but please feel free, okay? Because I like it to be interactive, as much interactive as possible out there. But I don't see any hands raised, therefore I assume there are no questions out there. Now, for example, you can see this slide which I've made. I could have made this like a standard type of things with bullet points. I've created it this way. This is an innovation in slide making out there, so that they are there and you get attracted to a slide like this. Very important out there. Now comes in, I will touch the area of intellectual property rights. So what are intellectual property rights? Intellectual property. So there are three intellectual property rights. So let's come to the word intellectual. Now, don't go to the word intellectual the way we generally think about intellectual. Intellectual word in the context of intellectual property rights are creations of the human mind. Any creation of the human mind is an intellectual activity. So we are not going into the word intellectual the way we normally interpret. The word intellectual in this context is creation of the human mind. That's point number one. Property. That means this creation of the human mind which we have created, when we convert that and go through a certain process and convert it into a property, not all the creations, if you don't convert it into property, it does not become property. You may be considered to be the author, but you may not be the owner of it. There's a difference between you being the creator, you being the author, and you being the owner. You become an owner only when you make it into a property. You get the point? Therefore, publishing a paper in a journal, you become the creator, you become the author, but you don't become the owner of that. So now we'll come to all those parts. What is the difference between being a creator and an owner? So intellectual property, so when you convert the creation of the human mind into a property, then you're converted into intellectual property. Now, the moment you've converted that into an intellectual property, this intellectual property is associated with certain rights. So it is intellectual property rights. That is how the expression intellectual property rights have to be looked at. And I will use this whenever I use the term IPR, intellectual property rights, I mean precisely that. Now let's come to, a few aspects, instruments These are legal instruments of intellectual property rights. Now, I'm sure many of you have heard the term called patents. Is there anyone who has not heard the term called patent? Anybody? Do I get, since there are no hands up, I assume that all of you have heard the term called patent. So I will now go through each one of these and then come to and define to you what are these terms. And mind you, very important, each of these instruments of intellectual property right are different from one another. And therefore, we need to understand the meaning of these terms. And we must learn to differentiate these terms one from the other. Now, when we come to the word patent, right? Patent is a legal tool, is a legal instrument which is used to protect inventions. Now see, I've deviated from the word innovation to invention. So patents protect inventions. And what are inventions? Very important. What are inventions? Then you will come and say inventions are not discoveries. Of course not. So inventions, what is an invention? Invention is, for example, when we went to the previous slide, the slide changed to the previous slide. Anybody to just tell me that the slide has changed to the previous slide? Are you seeing the previous slide? I'm not getting any response. Okay, thank you. Yes, good. So when we come to these products, devices, processes, new plant varieties, seeds, new microorganisms, etc., all these, when these are addressing technical improvements related to functionality, and we use methods of science and technology to address technical improvements or technical impact, the technical aspects of functionality. And if nobody has done it before and I have done it, then that becomes an invention. And it is those aspects of inventions that are protected by this tool called patent. So whenever you hear the word patent, immediately you will correlate that with an invention, point number one. The moment you address the word invention, you will correlate that with functionality, right? And that means that invention is something that addressed issues of functionality. Functionality. So whenever you've addressed issues of functionality using the ways of the methods of science and technology, that may lead to an invention. And if that leads to an invention and you want to protect that invention using one of the tools of intellectual property rights, you will use the tool called patent. So patent, you will associate with the word invention with functionality, and functionality or in any form out there. That is what a patent is all about. So you have to understand the word patent, and we will go into depths of patent in the next lecture. But suffice at this point that patent is a legal instrument that protects inventions, and inventions are related to functionality of products, processes, and services. So that's how it is, and that is what is protected by patent. When, again, I go back to the previous slide, when you are addressing aspects of aesthetics, that means you're disregarding the functionality and you are addressing issues of aesthetics. And how do you get aesthetics? When you address issues of shapes and ornamentation. If the shape and ornamentation, addresses functionality, then it will go into patents. But if the shape and ornamentation, when you disregard the functionality, it would then look into the aesthetic features. And these aesthetic features are not protected by patents. Why? Because they are not, you're disregarding functionality. And therefore, the legal tool that protects aesthetics by way of shapes and ornamentation is the word called design registration. So therefore, whenever you use the word design registration, you will understand that we are not addressing functionality, we are addressing aesthetics of that product. Product aesthetics can be protected by design registration. And when we say aesthetics, it is the shape and ornamentation out there. Okay, those are the two very important aspects in design registrations. But if that design, if that shape or ornamentation has got a functional aspect to it, then you may like to protect those functional aspects by using a patent, because that may be an invention and it is not merely the aesthetics of it. So we'll come to many of these things later on as examples. Now let's come to the third part of where you create, their creative expressions. So when you have creative expressions, like this slide, you see this slide, I've decorated these words in different ways. This is a creative expression of mine. The words here are not my words. They are all known words. But I've arranged them in such a way that this is a creative way of expressing. And therefore, this slide is a creative expression. And creative expressions by way of literary works. When you write a novel, when you write, any text, you write a poetry, you paint, you sketch, take a photograph, you do a sculpture, you create a video, you do whatever. These are all creative expressions of the human mind. And such creative expressions of the human mind is protected or can be protected by another tool of intellectual property right, and that's called copyright. And that is the reason every time you take a book and you flip the first 2 pages, you'll see behind saying copyright. Okay? Because that's a creative expression of somebody, and that book is protected by a copyright. So we have done so far, patent for functionality, copyright for expressions, patents for inventions, copyright for creative expressions, design for aesthetic aspects of. Similarly, there are certain products where when you put some symbols to it or you put some words to it, then those symbols or words, those expressions, those are there which give you some sort of an association with those products. For example, when you put down, a partially eaten apple with a little stalk here and that little leaf, immediately you associate that with the Apple company and the Apple products. Therefore, it's a mark used in the course of trade, and therefore that's called a trademark. So such creations are protected by what is known as trademark. Similarly, if you are talking about not a product, but a service, like a banking service, or your petrol pumps, their services. If you take some of those, then immediately, those are either have some symbols, like for example, if you write a per in brown color and put a dot, what does that indicate to you? That per with a dot. Does anybody know? You can put it in the chat box. What does that per with a little dot mean to you? Any idea? Any idea? Any idea? I'm not getting any response. What I'm saying is that, if you write the pa in Hindi, in Devanagari, you put in brown pa and put a dot in the pa in brown color. What does that indicate to you? If I don't say anything else, what does that indicate to you? PNB, yes, Punjab National Bank. You're absolutely correct. So see, you have associated. I only told you pa with a dot, and immediately you jumped and said, that's Punjab National Bank. So you associated that pa with a dot, in that brown color, all that with the service. Which is the service? Punjab National Bank. And therefore, that is the service mark of Punjab National Bank. And therefore, all these companies which provide services have some mark, symbol, or words out there together. Similarly, when you are, watching NDTV, or you're, listening to something from All India Radio or there or Doordarshan, then immediately that tune, and not only that, that Doordarshan has got a symbol like this, that even if nothing is written, you will associate that symbol with Doordarshan. Similarly, NDTV, etc. Those are all service marks because they are marks which associate, between that and the service that they provide. They are service marks. So I will come to the rest out there. So what we have done so far, we have done patent, protects inventions. Copyright protects, creative expressions. Design registration protects distinctive shapes and ornamentations. Therefore, it protects the aesthetic features of a product. And trademark and service mark are marks or sounds or words or symbols that associate that service or product with with that the way the consumers identify in the course of trade. So in this slide, you can see the written vision-IPR. This is the trademark of my company, which I started in 2001. And I called it Vision IPR. Vision, word is known, IPR word is known. All I did is connected the two with a little hyphen. Called it Vision IPR. And this is the symbol or the logo of my company. I registered it. And today, world over, people recognize Vision IPR as my company out there. This is very important. So this is what I wanted to very quickly do with you at this stage. Now we are coming to some of the features which are common, whether it's a trademark or it's a copyright or it's patent or it is design registration, whichever. Number one, who gives you this right? The state. State means the country, sovereign. Now in India, it is given by Government of India. So the intellectual property rights are given by whom? It is given by the state. State does not mean Maharashtra or West Bengal or whatever. State here means the country. So the country gives you, the government gives you. Okay. But what does it give you? It gives you ownership to the knowledge. So the difference between you being the creator, but now you are going to become the owner of that knowledge. Owner. So you get an ownership to the knowledge out there. So when you get a patent, you become the owner of that invention. When you have done a creative expression, you are given a copyright. And when you have the copyright, you are the owner of that creative expression. You have been the creator, but now you are the owner also. Okay? And therefore, knowledge ownership is given to you. And the moment that knowledge ownership comes, there's some rights that come with it. And these rights are not universal rights. These rights are territorial. So when Government of India gave you the right, it is valid only within the political borders of India. So therefore, if you want the right in other countries, you have to get the right in those countries. Okay? So territorial. And These are not given to you forever. These have a specific time period for which it is given. After that, it goes into the public domain. So we'll come to that part. So therefore, there's territoriality, number one, and there's a limited time for which that right has been given to you. Now, when these laws are created, these laws not only give you the rights, but it also creates what are known as exceptions. And those exceptions are that when the law is made, those exceptions are also created. Those exceptions tell you what all activities you can do without the permission of the right holder, without the permission of the owner, what you can do. So there are certain things you can't do without the right of the permission holder or the owner. There are certain things you can do that's permitted by law without going back to the owner of that knowledge. We'll come to that part later on as we go. And similarly, because you have some rights, there are some obligations, and you're supposed to fulfill certain obligations towards society. But if you don't fulfill those obligations towards society, then there are issues that you will face. So therefore, there are three important things. There's ownership, number one, the rights because of the ownership, which are territorial, and the term is time limited. There are exceptions which the law permits you to do certain things without the permission of the owner, and there are obligations that the owner has to meet because the society has given them the right. So this is where we stand on this particular. Now, so these are very loaded concepts. Normally, when you're doing research and you join these institutions, you don't think in the general terms, but you must start thinking. That's the whole idea of this particular course. And you must start thinking and broadening your perspective on knowledge and knowledge creation. Now, four very important things come in with this ownership. So if somebody uses my knowledge for which I am the owner without my permission, then the person is pirating my knowledge. But if the person is using my knowledge with my permission, then the person is prospecting my knowledge. Number one. Number two is very important that what about making the knowledge available to others? Am I making the knowledge accessible to others? And I may make it very accessible to others. But if it is not affordable, then what is the use of that accessibility? So there are questions that you have to ask. Simply making the knowledge available may not be very easy. But if the knowledge is very expensive, then there are issues in the societal part. So we'll all the time go back and forth between all this, that when and how we have to manage this knowledge in society where the knowledge is owned by people and some knowledge is not owned by people out there. And therefore, the issue comes in what? That I access the knowledge. The question which I should be asking, can I reuse that knowledge? Can I rework on that knowledge? Can I do reverse engineering on that knowledge? Those are the type of questions that, see, you're doing your research. You're using so much of knowledge from elsewhere. You need to ask yourself the question, all the knowledge that I've gathered from different places, can I reuse it? Can I rework on that? Can I reverse it? Can I recreate? A bunch of things that come about. And these are some very uncomfortable questions that we have to ask and answer. So when you consider the knowledge domain, there are two parts to the knowledge domain. Knowledge, one part of the knowledge domain is where public can use it in a completely unconstrained manner. There's another part of the knowledge domain where public can use, but it becomes a restricted use. So for example, can I enter BRC? There is Not everybody can enter. Therefore, it is not in the public, in that sense, it's not an area for unconstrained use by public. But can people enter? Yes, provided you are given permission to enter. Intellectual property is exactly like that. When you come to the property of intellectual property, the intellectual creation, and it becomes a property, then you can access that, you can use it, etc. But you have to understand that comes with some conditions in the usage of that intellectual property. Therefore, when you do your research, you have to know very clearly that the knowledge that you are accessing is that completely a public domain knowledge for completely unconstrained use, or is it a public domain knowledge which is there with certain conditions of usage? That is where the rules of intellectual property rights become so important. And I will show you later how these become important from the point of view of your doing research in any field or in any area that you are involved in. Are there any questions at this stage? I must tell you very clearly that I'm not used to lecturing to people who don't ask questions. Okay, I'm generally used to a very reactive audience, right? People ask questions, but somehow I don't see this audience asking any question. I would have expected, yes, you have asked something in the chat box. Okay, let me see. What is you have asked in chat? What did you ask? There's no question there. I don't see a question. What is the question? I've not seen a question. Well, can you raise your hand and can you unmute her, please? Can you unmute her so that she can ask the question? Why will it be called invention, not discovery? Discovery is when we find out what is already there. Invention is when I create. Okay, so invention is when I create. That was not there before. That is an invention. Whereas if there was something already there, yeah, go ahead.
Yeah, suppose some patents are there, like medicine and all, some properties of that compound are maybe existed before, but I have just discovered it, but people are patenting that too. So then why invention?
Yeah, now if those properties were already there and nobody knew about it, but I found out those properties, right? The point is that I found out the property. Therefore, in that particular case, it becomes a discovery because the property was always there. Nobody knew about it. I did not create the property. I only found the property. Therefore, it is a discovery.
Yeah.
Okay? Now, logo of a company or trademark.
In case of patent, we can't use only the inventions, but also discoveries.
Sorry, tell that again.
Means we can include discoveries also.
You can?
In case of patents, you told we
discoveries
can
cannot be
include discoveries as well.
No, discoveries cannot be patented because you cannot take ownership of what was already there. So discoveries cannot be patented. The discovery is not an invention. Patents protect only inventions. Clear? So that's the reason when you found out a new property, you may publish a paper.
Thank you, sir.
You become the author of that, but you don't become the owner of that property because you only found the property. Similarly, if you take the laws of gravitation, you take the laws of motion, those were things which are always there. People didn't know about it. Somebody came and said, that's the law of motion. That's what gravity is all about. So all those things are some things which are discoveries. But inventions are when you create. There was a question on trademark. 1 minute. Let me go back to the chat box. There's that logo of a company or a trademark or service mark. A company will have, that will be generally a service mark. The products of the company, whatever is protected by logo, will be a trademark. Sometimes the trademark and the service mark will be the same. Okay? Sometimes. Clear? So, yeah, good. So now we go further out there. So therefore, when we come to innovations, if someone, 1 minute, again, there is some question in the chat box. What are the instances when service mark and trademark will be the same? Yes, good question. Now, for example, if you take that, if, if there is a company whose name, the company's name and the product name, if it is the same, in that case, the service mark and the trademark will be the same. There was any other question? Let me just check. I thought there was one more question. It says, researchers, during initial days of COVID, when worldwide researchers are trying to find vaccine, most of the countries were requesting not to register patent. Can you please comment on? Yes, you're a good question. That when all this was happening, people were saying, you create this vaccine, please do not patent. Because the moment you patent it, it becomes your property. And then in that case, you cannot, that means in that case, what happens is that others, if they want to create the vaccine, manufacture the vaccine, they only have to come to you to take permission. They cannot do it otherwise. And therefore, that's a big open question. And I will deal with this question in some detail in my lecture number 2 or 3. Okay, out there. Now, therefore, when you take different aspects of innovations, you can protect the same innovation, different aspects of the innovation with different tools of intellectual property rights. For example, if I take, this iPhone, all the functional aspects of this iPhone are protected by hundreds of patents. Functional aspects, the inventions that have gone to make this iPhone are protected by many, 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 many patents. The shape of this and the ornamentation of this is protected by design registration. For example, Apple has a lot of design registrations on these iPhones. Then a lot of this software and other things are protected by copyright. And the Apple symbol with that is protected as a trademark. So you can see that this itself, various aspects of this is protected by various elements of intellectual property rights. Patents, as we show here, are inventions and functional aspects which are there. Trademarks, as I showed you, that Apple symbol, that partial in Apple is a trademark. The shape of this is an industrial design. The software of this and many of the other aspects of this are protected by copyright. These aspects, mind you one thing, that patent, trademark, industrial design, and copyright, if you want the protection of this, then you have to disclose. Whereas certain aspects of this, Apple has never disclosed and got a patent or trademark or industrial design or copyright. They kept it as a know-how and trade secret that they kept to themselves. They did not disclose to anybody. And many of the integrated circuits may have been protected by using what is known as layout for integrated circuits. So you can see that this device itself is something where different forms of intellectual property rights have been used to protect different features of this particular product, right? So now the question somebody has asked in the chat box out there, I think it was Ajit Singh, has asked, will the patent protect forever or any timeline on restrict to use publicly? Yes, there is a timeline. I will go into details of it, but just for you today to answer your question immediately, that if you file a patent and get a patent granted to you, then that particular life of that patent is only for 20 years from the date of your filing. After the 20 years are over, it goes into the public domain and anybody can use that particular patent. Okay, just to answer your question. Okay. Now, so this is where we stand in terms of how these are done. And so, in this case, now I come to how to integrate this in research and R&D. Therefore, I call it R&D interwoven with intellectual property rights. I will just take 2 minutes and I'll continue from here next time. But important part is that when all of you are doing research, you're all starting with concepts. Then you take the work and do some work. You get some output, and some part of it may go to the market, may not go to the market. But mind you, very important, that is at the concept stage. You do literature search. Correct? All of us do literature search. Normally, you will be doing literature search in journals, books, and various other things. Very seldom researchers go and look at patent literature. And I will end my lecture by only saying today that you'll be surprised if I tell you that if you're working in a field like nanotechnology, materials, in a field like, something on structural engineering, you're working on artificial intelligence, if you're working in biotechnology, and many of these frontline areas, mind you, more than 60% of the knowledge is there in patent literature. And that does not come generally in journals, books, and other literature. Which means that if you have not looked at patent literature while doing your literature search, you are working and designing your research only on about 40 to 50% of the knowledge domain. And therefore, the research that you're doing possibly is already repeating what is known without your knowing it, number one. And number two, if it is patented, then you're doing something. And if tomorrow you want to go to the market with it, or you want to do a technology transfer, you will not be able to do it because somebody who has the patent will then come and tell you, hey, I have the patent, I will stop you. Then in that case, all your research will get into real trouble. So that first part, problem identification, knowledge, including IPR landscaping. So you need to landscape. If you're working in fields of technology, science, if you do not look at patent literature, then it's very dangerous. You're working on a very small base of literature. Therefore, I will show you later how to access patent literature because that's all available in the open domain and you can access those things. And so, therefore, you will have to create a landscape of the knowledge landscape, including patents out there. And only then you will find that you would have done a reasonable job of that particular. So I will stop at this stage unless you people have any questions. So please ask any question in the next couple of minutes that we keep it open. I've kept the chat box open. So if you have any questions, ask, or you raise your hand and you can physically ask the question if you would like to. So we'll wait for a minute or two, and if there are no questions, we will log off for today. Is that okay? I don't see any questions. I don't see any questions. So we will then end the lecture today at this stage, and we will pick up the lecture tomorrow from here onwards. Right? I think tomorrow we have a lecture, don't we? We have a lecture tomorrow, yes, 17th. So we will pick up from this slide. Okay? Is that all right? Okay. Professor Tomar, thank you very much. I will stop sharing and log off. Okay? Thank you.